Hello, I'm Ian Gascoigne, presenting a webinar for MBL entitled Choice of Court, a bite-sized guide to the rules and requirements for civil litigators. This topic is all about having options. We're very used to having options in day-to-day life. If we go to a coffee shop, we're going to be presented with questions concerning what strength of coffee we might want, what size of cup, even what sort of milk we might enjoy. Equally, if we're looking for an energy supply, there's lots of suppliers in the market we could select. But in some areas of activity, there's no choice at all. So if we want to vote in an election, we have to vote in the constituency in which we're registered. We can't shop around for a more attractive candidate somewhere else. And so too, if we want to watch a television program on television, we can't do that unless we have a license fee, or we shouldn't do that without a license fee at least. In those instances, we have no option at all. In terms of claimants pursuing claims in the civil courts, they fall between those two extremes. So they have some degree of choice, but there are some restrictions too. And that's what this webinar is about. The topics I'll be covering are to remind you of the options of courts and to ask whether we always have a free choice or sometimes there is a prescribed court. I'll briefly look at the question of venue, whether to start a claim in London or to use a regional centre. One of the issues will be case management and litigation processes operating between different courts. I'll mention the transfer powers the court has under CPR 30.5 and the Practice Direction 57AA. And I'll also have time just to mention the online pilot schemes currently running.